Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, February 9th, 2022. The time is 9:30. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith, and I'm John Neerman. Today's meeting is a hybrid meeting, and most of the participants are joining us virtually, so I'd like to ask that you please keep your microphones muted when you are not speaking. For each item where argument or comment is allowed, we will inform speakers of their time limits. For those who are presenting, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. With those admonitions out of the way, thanks everyone for being present, and Ms. Smith, please call the first item.
Item number 1 is the ALJ's consideration of the ALJ's proposal for decision and order regarding an appeal of the denial of Michael Gaines's application for a landscape irrigator license. The applicant should speak first, followed by the ED, and then the Office of Public Interest Counsel in that order. OGC recommends 5 minutes each for oral presentations, and the applicant may save some time for rebuttal as he bears the burden of proof.
Thank you, Ms. Smith. And Mr. Gaines, are you with us today?
Yes, sir, I am.
Well, good morning. The floor is yours, and you have 5 minutes, and whatever you don't use, you can use for rebuttal at the end of the other comments if you like. So go ahead when you're ready, sir.
Okay, yes, sir. Okay, so I just want to start by saying, okay, so I've never learned anything in my life ever, but I've learned irrigation and landscape. So I want to be a licensed irrigator, because it will put me in a better position to help people, to either get their life together or either turn it around through hard work. And I promise, that irrigation has been a big factor in the radical changes that I've made in my life. I don't use drugs. I don't party. I don't have run-ins with law enforcement anymore. I work and I'm always busy Monday through Saturday from 6 in the morning to 6 in the evening, and I'm always being a productive citizen. And, so I don't have a big climactic speech, to say why I should be able to take the test, even though I've paid for the class and I've been studying since, for a hard job, and that's only about to get harder, once I pass this test, and no disrespect to anyone, but if there is no need for a high school diploma or a GED or even minimal work experience or even a basic drug testing, then how high of a risk is this license? And I did a quick background check, and a quick background check and a facial expression, it doesn't exactly tell who a person is. I'm not a murderer. I'm not a sexual predator. I'm not vindictive, and I do not have a temper. And also, I also want to say that in the state of Texas, the limitation on background checks is 7 years, unless the position is paying at least $75,000 a year. Correct me if I'm wrong. And a licensed irrigator in Texas only makes between $50,000 and $55,000 a year. So, and it makes me wonder, was I subjected to an unfair background check? Because it's been like 12 years and I've been free exactly 8 years and a month. And January 7th, 2014, and I have been the model citizen. I vote, I pay my taxes. I do company picnics and, planning summer job programs for, more susceptible youth in my community, and in conclusion, I have provided everything that I can to prove that I am who I say I am, including certificates, letters from people that know me, and from my employers who has expressed full support on my journey to become a licensed irrigator. So I sincerely hope that you can see that I am a remarkable exception to the rules that you guys have, and to use me to set the new standards or revise the standards that has currently been set. And I thank you for listening, and I thank you for giving me a chance to prove that I am a good guy. And also, if I do get approved, I thank you for this long process, because it has given me more time to study, to be able to pass this test in one try, so. But that's pretty much all I have right now, so that's it.
I think we got it. Thank Mr.
I
Gaines.
thank the rest for rebuttal.
Yes, sir. Thank you, Mr. Gaines. And
Yes, sir. You're welcome.
And
I thank you.
and we're aware of the record before the administrative law judge, including the letters or testimony from your employer and your landlord. Colleagues, any questions for Mr. Gaines? All right, seeing none, let's hear next from the executive director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Alicia Ramirez, and with me is Ms. Haya Zeman, PE, Deputy Director of the Occupational Licensing and Registration Division. We represent the Executive Director in this matter. As discussed in our exceptions to the PFD, the Executive Director disagrees with the Administrative Law Judge's proposal for a decision and proposed order and recommends that the Commission reject them. Specifically, the Executive Director objects to conclusions of law 9, 10, and 11 and finding of fact number 26. The Administrative Law Judge concedes in the proposal for decision that respondent offered no evidence of his rehabilitation or rehabilitative efforts. However, in conclusions of law 9, 10, and 11, the ALJ erroneously concluded that the respondent met his burden of proof on the application and that he proved his fitness to be a landscape irrigator, and therefore his application should not be denied. In finding of fact number 26, the Administrative Law Judge found that respondent was penitent and did not have a temper. There is no evidence in the record to support this finding. Based on these objections, the ED recommends that the Commission rejects the Administrative Law Judge's proposal for decision and issue its own decision that is consistent with the foregoing arguments. We reserve the remainder of our time, and we are available for any questions.
Thank you for that. I have none. Commissioner Lindley, any questions? Commissioner Janeka?
No, thank you.
All right, let's hear next from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Amanda Pessinen for the Office of Public Interest Counsel. OPIC respectfully requests that the Commission decline to adopt the ALJ's proposal for decision recommending granting respondent Michael Gaines's application for a landscape irrigator license. OPIC, the Executive Director, and the ALJ are all in agreement that the Commission is legally authorized to deny the application because Mr. Gaines has been convicted of offenses that directly relate to the duties of the licensed occupation. OPIC and the ED also agree that Mr. Gaines did not satisfy his burden to prove his fitness for the license. As detailed in OPIC's exceptions to the PFD, OPIC specifically accepts to finding of fact number 26 that Mr. Gaines is penitent and does not have a temper. The record contains little evidence to support this finding and some evidence to directly contradict it. Most importantly, OPIC questions whether Mr. Gaines has been sufficiently rehabilitated so as not to jeopardize the safety of the public. OPIC also accepts to conclusions of law 9, 10, and 11, which conclude that Mr. Gaines satisfied his burden to prove his fitness for the license, that he demonstrated his fitness to be a landscape irrigator, and that his application for a landscape irrigator license should not be denied. Mr. Gaines's DPS report reflects 9 years of criminal activity and includes multiple convictions for violent offenses, including domestic violence assault and assault on a public officer. The landscape irrigator license is classified by the agency as high risk because it would grant access to persons in situations that could have a potential for confrontational behavior related to crimes against persons. The nature of many of Mr. Gaines's criminal convictions falls squarely within the type of risk this license seeks to prevent. Moreover, even the ALJ's analysis in the PSD recognizes and OPIC agrees that there is no evidence in the record regarding Mr. Gaines's rehabilitation or rehabilitative effort. OPIC maintains its position that the ED appropriately exercised its discretion in denying this license application and respectfully recommends the Commission affirm the EP's decision. Thank you, and I'm available for any questions.
Thank you. I have none. Commissioner Lindley, any questions? Commissioner Janeka?
No.
Okay. Mr. Gaines, you've got about 1 minute and 20 seconds if you want to add anything else. I think we understand your comments and where you're coming from, but I'll just turn the mic over to you, and you can add anything else before you that you'd like before we take a vote on this.
Well, yes, sir. I just want to say, of course, I know, that, when I was younger, I got in trouble. But, one of the my victims, or, my domestic violence case, we're even still friends. I got text messages from her the other day. But, overall, I'm a good person, and, I know that's my background, and I'm trying to focus on the future. I'm trying to help people, and I'm trying to stop people from making the same mistakes I've made. And I know I'm always in confrontation. Well, not confrontations. People sometimes they have problems with me, and I don't do anything. I don't do, I don't say anything. I don't get in any trouble. I don't, that's all I can say is I'm an upstanding guy. I'm a great guy. And, and I promise that I understand the consequences to any actions. And I have held myself accountable, and I promise if I'm granted the chance to go and take this license that, I won't, let anybody down. I won't let myself down, my family, and I'm going to do what I got to do to be the most, the best person I can be, basically. So, I mean, that's all I have. And, and like I said, I thank you guys. So,
Well, thank you, Mr. Gaines.
Yes, sir. Yes, sir.
Yeah, appreciate your comments. Colleagues, these are always difficult cases, in part because as environmental regulators, we lack the expertise in rehabilitation and recidivism. Those just aren't, I have difficulty even saying the word. These are not areas where we have a lot of experience or expertise. So that's always a challenge. But it is the administrative law judge's role to weigh the evidence, and I don't have a reason to second guess the findings and conclusions here. Mr. Gaines' crimes are certainly very serious. They are indeed relevant to his fitness to hold this license, but he served his time. There's no evidence that he has reoffended in the last decade. There is credible testimony that he is a model employee and a model tenant. In my mind, that is evidence of rehabilitation, even though there was no formal coursework or testimony from a credentialed behavioral expert. So I'm aware that there is some risk here of Mr. Gaines reoffending, but I don't think that risk is going to be diminished by denying this license. So my view is that we should adopt the ALJ's proposed order. Commissioner Lindley.
I'm in agreement. This one was tough, and I respect the ED's work on this. I think they had a tough case here, and I don't know what the right word to say is. I guess impressed. Mr. Gaines represented himself. We don't see that a whole lot, and while that doesn't factor into the determination, I will just note that I would note that makes him very serious about pursuing this. But I agree, going off what's in the record, I'm comfortable adopting the ALJ's proposed order.
Commissioner Janeka?
I think that makes a unanimous position across the board. I'm in agreement as well. I think that the administrative law judge really carries the burden, the large burden of this decision, and their findings are very, very convincing in my view. I think that they're best positioned, best suited to make that judgment about Mr. Gaines' suitability in regards to this license, and I'm comfortable moving forward today.
I think we're ready for a motion.
I would move that we adopt the administrative law judge's proposed order.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by San Antonio Water System for water use permit number 13098. The parties have been notified that the commission will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
So, colleagues, while hearing requests for bed and banks permits are not subject to House Bill 801 or Senate Bill 709 requirements, we do grant them under Chapters 295 and 297 when the requester demonstrates its right to a hearing under Chapter 55, Subchapter G of our rules. And at the heart of those requirements is the familiar affected person analysis, including the requirement to articulate a personal justiciable interest. So let me begin with GBRA's request. Much of the argument much of the request is based on the argument that the Edwards Aquifer is hydrologically and legally distinct from other groundwaters in the state. And hydrologically, it is distinct and may well function as a tributary to the Guadalupe River. I am skeptical of the notion that it is legally distinct. Groundwater is private property, and the Day case confirms that it retains that character when it's discharged into a state water course under a Section 11.042B authorization, also known as a bed and banks authorization. I understand the concerns about the effects of SAW's groundwater pumping on inflows to the Guadalupe River, but SAW's right of capture is not at issue in this authorization. This authorization is for conveyance. However, GBRA also expressed concerns about the proposed accounting plan and channel losses in the river, and in my view, this is a personal justiciable interest, and it's not difficult to imagine future disputes over the accounting plan, particularly where SAWS may allege that GBRA took SAWS privately owned groundwater-based effluent. And I think GBRA was clear in its concerns that SAWS may come after them for water. And I'd just like to reference a couple of short portions of the GBRA brief. And this, beginning on page 13, they start to articulate how they are affected in a manner different from the general public. And on page 14, they say, the proposed accounting plan inadequately addresses channel losses from the point of SAWS discharge to the proposed diversion point at the mouth of the Guadalupe River. And then continuing on the next page, and I thought this was really interesting, SAWS application would effectively create a most senior water right that could call on any water right holders upstream. So the request is couched in language that's borrowed from the prior appropriation system. They're talking about senior water rights. They're talking about a call. But they also use that word effectively. It is to this effect. And, I don't think it matters that TCEQ would not recognize a priority call by SAWS because SAWS can call for the water to similar effect in a private cause of action in district court. So I think to deny their request based on how they've articulated it when the root of their concern is that SAWS may come after them for water would just be slicing it a little bit too closely. So the bottom line for me is that GBRA does indeed have a personal justiciable interest, and they articulated it sufficiently to establish standing. So I would grant GBRA's request. Union Carbide may be similarly situated, but its request is quite short and does not, in my view, raise a personal justiciable interest. And the other requesters are not located within the conveyance reach, so any concern that SAWS may come after them for interfering with the conveyance is just a little too attenuated for me to find a personal justiciable interest. So I would grant for GBRA and deny the rest. And let me pause there. I know this is a complicated item. I think every lawyer that looks at it probably has a different take on it. Lawyer and commissioners perhaps too. So Commissioner Lindley, what do you think?
I'll probably have to pause at some point and gather my thoughts. I will say that, this is super complicated. I mean, this one I've wrestled with big time. And I was actually very excited to hear your lawyer thoughts on it today. So thanks for diving in and sharing those. I will be interested to hear what the issues are, I guess, that you'll, want to refer.
Yeah, and I would just, we're not required to
Okay, that's right. Water
specify
rights,
issues, and I probably would not do that.
Okay,
Yeah.
okay, that's fair. Let me say this initial comment, and that might be all I need to say. I had made a lot of comments, and so I'm going to somewhat stick to them because I don't want to get too off course here, which is not tongue-in-cheek. But so, yes, I read, what happened for me was I read all the hearing requests, and I thought there were some very interesting points made, very interesting. And so I dove into the points made, and like I said, I wrestled with it. And one thing I kept saying in my mind over and over again was, what does this mean in the long term? This is to me, this could have some policy, arguably some substantially policy decisions interwoven. And I had a hard time finding in the comments what I wanted to see exactly, but hearing how your interpretation of GBRA's comments actually kind of helps me. That's kind of where I wanted to get, and I wasn't able to get there over the past 2 days. That's very, very candid. But I can get where you're coming from, and I could get on board granting a hearing to GBRA because I shouldn't say trying to find that, but I felt like there was an underlying policy issue that was there, and I couldn't. Anyway, I think you found it, and I'm okay. I'm on the same page as you are. I'll leave it at that.
All right, appreciate that. Commissioner Janeka.
I don't have much. I don't have anything really substantively to disagree with, so I won't be long and belabor it. But I keyed in as well, Chairman, on the distinction in my mind on GBRA's comments about that water accounting plan, the specificity of their concerns, some of the real direct impacts that they alleged in their hearing request that didn't match the specificity or the directness of some of the other requesters. And I agree with you, it's a somewhat tenuous link given that all the requesters there's different views on the applicability of the laws and the interplay of which laws and which reading that prevails. Like you, I agree. We've got a plain reading of the laws, a court decision in our favor. There's strong evidence in my mind, and I have a high degree of confidence that our position proposing to go forward with this bed and banks authorization is appropriate. However, there was something there, and I appreciate the way that you put it, Commissioner Lindley. I think that my mind immediately went to the counterfactual of this looks great now. What would this request look like in the context of a very severe, significant drought if our state were really in the midst of that? And what do these policy issues look like at that point in time? So I think that there is certainly a little more detail I would like to see fleshed out to the concerns about that water accounting plan process that the GBRA has articulated, and I'd be comfortable moving forward with them as a affected party. But I think we might need a moment for me to consult to get the appropriate wording for that motion, unless you might have that ready.
I actually have a motion to offer to that effect. And I guess what I would say is, I haven't formed an opinion on the accounting plan. I think it's GBRA's right to challenge that before SOA and to work through that process, to have that process essentially. And I'll just add, one of the things that I struggled with here is the legal paradigms don't match to the hydrology very well. You have prior appropriation for state water, surface water. You have rule of capture for groundwaters. These waters interact. We know that, but the legal paradigms aren't quite up to the task of accounting for all that. And now what we're doing is we're putting private groundwater-based effluent into surface water, and these molecules are traveling with each other, which just further complicates matters. And so what I struggle with teasing out is what is the interest? I think there's some interest in fact related to the hydrology that don't exist at law. And so focusing on the test or the criteria that we apply, what is the personal justiciable interest that signals what is the legal interest. I looked for the legal interest, but all right.
Very, very well said.
That's
I will say that.
I think our general counsel may think that I said too much. We don't know.
Me too.
That's my
Always.
that's my prerogative, but I appreciate your good advice that she sends me telepathically. And with that, colleagues, and also let me just add two things that are going to be features of this motion. Obviously we've taken this matter up, we're addressing it already, so I'm going to deny the plea to the jurisdiction. I'll do that expressly in the motion. I think since we do just have one other party, that an ADR referral is appropriate, so I'll include that. So colleagues, I move that we deny Guadalupe Blanco River Authority's plea to the jurisdiction, that we grant the hearing request of the Guadalupe Blanco River Authority, that we deny the requests of Union Carbide Corporation, the cities of San Marcos, Seguin, and Victoria, INV Nylon Chemicals Americas, LLC, New Braunfels Utilities, and Victoria County Navigation District. I further move that we refer this matter to SOA for a contested case hearing on the application. And finally, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, I understand the next item is remanded.
That is correct. It was remanded yesterday on the motion of
All right,
the
so I'll
ED.
ask you to call item 4 then, please.
Item number 4 is the consideration of gifts and donations of $500 or more in value given to the TCEQ submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Chen of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days, in accordance with Chapter 575 of the Government Code. The Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka?
No, appreciate the report.
Ms. Smith, has anyone signed in to address this item?
No.
Mr. McWhirter, good morning. What do you think?
OPEC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the Executive Director.
I agree with that, colleagues. I think we should move forward with approval.
I agree.
I will move that we approve the issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCQ Interoffice Memorandum to the Commissioners dated January 21st, 2022, docket number 2021-1619-MIS.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next items.
Items 5 through 14 are our enforcement docket. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel.
For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 14. The total assessed administrative penalties are $915,798, with $180,772 deferred, $372,289 applied toward supplemental environmental projects, and $362,737 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none right now. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Not at this time. Thanks.
And Ms. Smith, I understand we may have some folks signed in to speak on the docket.
We do. We have several people signed in on item number 9.
Okay.
And to allow enough time for all who wish to be heard during the meeting, the commission will limit initial comments for each speaker to 3 minutes.
Okay, and who is the first? How about if I just ask you to call them up?
Sure. Ms. Kathy Scurro.
Good morning. Good morning. I wasn't sure if there was somebody joining virtually in person, but it's good to see you
I'm
here
here
in person.
today.
Thank you for being here.
May I take my mask off?
Of course.
Thank you, thank you. Mr. Chairman, Commissioners, and General Counsel, my name is Kathy Scurro, and I am the mayor of the city of Portland. I'm also a licensed professional engineer in the state of Texas. Thank you for the opportunity to speak with you this morning on a matter of utmost importance to the city, the enforceability of the enforcement order proposed for issuance to Voestalpine and the order's failure to establish enforceable, quantifiable, and measurable standards for compliance. The city submitted written comments to the TCEQ almost 2 years ago, raising these concerns. Although the staff finally responded to our letter a month ago on January 10th, the response is inadequate to address the concerns because, as Senator Zaffarini and Representative Lozano have already advised you in their letter on January 19th, the response contains no underlying facts or rationale supporting its conclusion that the order is enforceable. Our attorney will address these deficiencies in more detail later. I would like to spend my time on explaining the city's interest in this proceeding. While Voestalpine is not located in our corporate limits, it is directly adjacent to 2 large neighborhoods and subdivisions that are located within the city, which have been substantially affected by fugitive dust emissions from Voestalpine's facility. In fact, these emissions have had a citywide impact, which began shortly after Voestalpine began in 2016. These problems can be traced to Voestalpine's decision early on to build and maintain large open-air stockpiles of this dust, once they realized that this dust might have commercial value, even though the stockpiles were not authorized by their air permit. It is our understanding that these stockpiles were later covered by a permit by rule and are now proposed for authorization in their air permit amendment pending with the TCEQ. However, they should have been authorized prior to their construction, and the TCEQ's failure to enforce pre-construction authorization has helped create a significant environmental damage in our community. The TCEQ is acquiescing in authorizing non-compliant operations through the permitting process, and Voestalpine is not alone in this regard. The city has determined that virtually 100% of the most recent industrial facilities located in San Patricio County have submitted permit amendment applications to the TCEQ requesting authorization of as-built facilities and equipment, defeating the TCEQ's longstanding policy of pre-construction review. The proposed agreed order does nothing to correct these abuses. The plan upon which the proposed order is based uses the technique of establishing unenforceable target goals for the treatment of stockpiles to reduce emissions, compliance of which can be excused by Voestalpine simply by keeping records of why their treatment of the stockpiles. We have little confidence in these measures to protect our city. I'm available for questions.
Thank you, Mayor. Colleagues, any questions for the mayor? Thank you for being here. Appreciate your comments.
You're welcome. Thank you so much.
Ms. Smith.
Mr. Randy Wright.
Good morning, Mr. Wright.
Mr. Chairman, good morning. I have some handouts for the commission. Can I?
Right here.
Mr. Chairman, Commissioners, General Counsel, Public Interest Counsel, good morning. My name is Randy Wright. I'm the City Manager for the City of Portland. I want to follow up on the Mayor's remarks about the impact of First Alpine in our city by showing you the maps that I've just handed out. Those images are Google Earth images that are available to the general public. They show a time span from 2014 to 2020. The first image is dated 2014, prior to construction of the plant. And the first, you can see the property is generally unaffected. As you move to the right, beginning with the second image dated February 2017 and continuing with the third image dated August 2017, you can see that the dust associated with these illegal stockpiles described by Mayor Scirò is now clearly visible. The final image dated January 2020 shows the dust completely covering areas of the facility, grounds that were once pristine areas. So shortly after the facility commenced operations, the city began to receive complaints from citizens about metallic dust on their cars, on their houses, on their outdoor furniture. This dust had settled in swimming pools. It was stuck on the surfaces. The dust emissions, they can't simply be swept away. They actually adhere to surfaces. Actually, First Alpine issues vouchers for citizens in Portland to have their cars professionally detailed using a clay block to remove these particles. So it's not just dust. So these emissions just couldn't be removed without help and professional help. So those people that are living closest to the facility have sustained the most damage, obviously, but quite frankly, practically the entire land within our city limits has been affected. And the stockpile dust at one time or another since First Alpine began operation continues today. The event or the extent of the impact depends largely on the weather, the wind conditions, the temperatures. So it's really not easy to rely upon a single inspection to determine the severity of the issue. And that's why these Google Earth images are so important, that you can see this over time. So I appreciate the opportunity to address you today, and if you have any questions, I'd be happy to do that.
Mr. Wright, thank you so much. Colleagues, any questions for Mr. Wright?
No, thank you, sir.
Thank you, sir. Thank you for being here.
Ms. Mary Reagan?
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel. My name is Mary Reagan for the record, and I'm an attorney representing the City of Portland today. On May the 4th, 2020, the city filed a lengthy comment letter in this docket, raising concerns about the enforceability of the order under consideration this morning. That's because compliance under this order hinges on compliance with a submission plan authored by the respondent that is largely a narrative document containing target goals and aspirational statements of respondents' subjective intentions rather than fully enforceable obligations. The TCQ issued a response to our letter 21 months later on January the 10th, claiming, quote, implementation of the approved plan is enforceable, end quote. This contention does little to allay our concerns because it's a conclusory statement without underlying facts or analysis, the absence of which precludes our effective review of your contention and also generates skepticism about the good faith nature of the executive director's response. Courts in particular have written about the weaknesses of conclusory statements, remarking that such statements are not credible and are not susceptible to being readily controverted, and referring to them pejoratively as threadbare recitals that have no merit in jurisprudence. In submitting written comments, the city appealed to the TCQ in utmost seriousness based upon our interest in protecting the public health and safety of our residents. Yet instead of receiving an equally serious reply the TCQ issued a response impoverished of any reasoning and analysis, an approach that diminishes the legitimate role of local governments on matters relating to public health and safety. We urge you to restore that relationship by acknowledging the merits of the city's position and revising this order to contain enforceable requirements. Finally, relying on perceived conditions on the ground today, which is only a snapshot in time to justify issuance of an unenforceable order, is extremely ill-advised. By its own terms, this order has the potential to be in effect for a very long time before issuance of an updated viable permit document, a circumstance that underscores the public interest that Voestalpine be subject to an order that is fully enforceable over the duration of the permitting process. I appreciate this opportunity to address you, and I'm available for any questions.
Thank you, Ms. Reagan. Appreciate the presentation. I have none. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka?
Thank you.
Thank you. Ms. Smith, who's next?
We have two people from Voestalpine who are signed in and are available if the commission have questions.
I have none. Colleagues, any questions?
No.
Okay. And let me ask if they would like to address the commission based on anything that they've heard. And there's certainly no requirement to do that, but wanted to present that opportunity.
The first person on my list is Ms. Gail Ridgway.
Ms. Ridgway, would you like to address the commission?
There we go. No, sir, I have nothing to say at this time.
Okay, thank you.
And the second person is Mr. Michael Chernikoff.
Mr. Chernikoff, any same answer, or do you have anything to share with us?
I would like to share a few thoughts, if I might.
Of course.
I am an attorney representing the company Voestalpine, and I thank you for the opportunity to respond. I merely want to say that the company and the TCQ staff have worked a long time through this order, and have worked a long time on developing the work plan that is the subject of the, complaint by the city. The work plan was not obligated to be implemented until the order became final by commission action. But notwithstanding, the company initiated the activities that were required by the work plan immediately and has substantially completed all of the work required of it by the work plan that was, negotiated and established with the TCQ staff. And we believe that that effort has been a successful effort, notwithstanding the claims by the City of Portland today. I point out that this is not an adjudication of the factual allegations, but nevertheless, I believe that there has been substantial progress made by the company, and we believe that the order is appropriate, and we ask that the commission approve it.
Thank you, sir. Appreciate your comments. Commissioner Lindley, any
No
questions? Commissioner Janeka?
Thank you.
All right, Ms. Smith, is anyone else signed in to speak on this item, item 9?
No, nor on any of the other items in the enforcement docket.
All right, well, we'll come back to this, I imagine, have some discussion around it. But in the meantime, Mr. McWhorter, let's get your take on the entirety of the docket, including item 9, and floor is yours.
OPIC reviewed the enforcement items, and we recommend approval of the proposed orders as presented by the executive director. With respect to item 9, OPIC is very sympathetic to the concerns of the community members who experienced nuisance conditions during the 2017-2018 time period addressed by the order. As to the written comments expressing concerns about the order's enforceability, it's understandable to OPIC that in May of 2020, 2 years ago, when the comments were filed, elements of the corrective action plan to address nuisance conditions could have been questionable as being too vague and unquantifiable to provide much assurance. However, it seems today, from what we've been able to gather from the situation and the backup materials, that almost 2 years later, it seems much of the plan, as the gentleman mentioned, has been implemented or is in the process of being implemented. And also the order itself requires completion, I believe, within 30 days of the order's issuance. Given that, OPIC trusts that the ED is monitoring progress under the plan and will enforce the order. Also, as the ED has stated in responding to comments, any additional nuisance events are subject to further enforcement, and those future efforts could be ramped up if violations of this order are documented and the order has been included in the respondent's compliance history. So for those reasons, we support this order and the rest of the enforcement docket.
Thank you, Mr. McWhorter. I appreciate that. Questions,
No? Thank you.
thoughts, Commissioner Lindley?
Well, I'll let someone else go first on this one.
Okay, Commissioner Janeka?
I do have a few. I appreciate Mr. McWhorter's recognition of all the work that has been done on this order and the length of time that has elapsed from many of these substantive comments arriving at our agency's door and where work continues to go on at the site. And I want to acknowledge my gratitude to Voestalpine for proceeding with that work ahead of actually having an order become effective. And I think that that's always worth acknowledging and applauding and thanking in efforts. I think that there is a tremendous amount of effort, a tremendous amount of resources attached with this investigation that brought us here, and I want to acknowledge the executive director's staff responding to over 100 complaint investigations, including tape lift samples. There's a tremendous effort in carrying out this investigation. The length of time that's elapsed, the progress that's been done on the order, I think these are all really right factors in my mind where we could take a closer look at the ordering provisions and make sure that where we've heard from our local partners who help us across the state in carrying out our agency's enforcement functions, where we rely on cities and local municipalities, county governments, the partners out across the state to help us on enforcement. I think that's a very important voice for us to heed in this space. And so I would suggest we could take a closer look on a few of the elements that are in the order. Specifically, first of all, the plan referenced in ordering provision 3C of that order, I would suggest could better serve the public in trying to incorporate that into the order as an attachment, provide a little more public transparency, a little closer scrutiny at this point in time when we're ready to commit to this agreement with this facility. I would also suggest we could take a closer look at what projects have been completed to date in those plans and try to have the order, ensure that the order reflects that so it's very clear to the public and those of us reviewing it what work still needs to be done, if any. And I appreciate hearing from Mr. Chernikoff that all of the work has been done, and I would love to see that reflected and credit taken in the order before we move forward. And finally, I think that where the order contemplates or requires the respondent to amend their NSR or PSD permits, the references to those permits throughout the order were a little murky to me, and I think that a closer look, passing back through to be sure we're very clear and very specific in which permit or which authorization we're referring to in terms of what requirements we would impose upon the company. All of those would be clear ways that jumped out at me on a cursory review at this point in the game. I'm in support of remanding item 9 back to the executive director for further work.
Thank you, Commissioner Janek, and I'm glad you brought that up, and I'm glad you were so specific about it. The city's arguments about enforceability did resonate with me. I think they're right on that. I do think it's appropriate to remand this item to tighten it up. It sounds like you've got some specific notions in mind, including attaching the work plan to the order and so forth, that maybe you'll be in a position to create a motion around. I think I would support that. Commissioner Lindley, what do you think?
I'm supportive of remanding item 9, and I think we're probably going to go there in a second. Well, let me say this. I'm also supportive of remanding item 12. I don't want to forget to include that. And so we can talk about that now, or we can do that in a minute, but,
I have just a couple of
Yeah.
closing thoughts on item 9. So when you're
Yes,
when
no.
you're ready to move
I was
forward
gonna say,
to
I
12, let
can,
me know and
I think I'm gonna be in complete agreement with whatever gets proposed, or I can make a motion on 9, but yeah, I think including deadlines for the projects and the ordering provisions, would be something we should remand as well, and I think y'all said that, but I just thought I would add that, so I'm finished.
Did you get that?
I think I did. I'm glad to hear that some of the items that I heard deadlines for outstanding projects. That's exactly what I zeroed in on as well.
Okay. So I think where we are in item 9 is we all share concerns about enforceability, and we're going to remand to tighten this up. Even though we do spend a little bit of time, there might be a little bit of delay. There's a trade-off in that. I do think that it seems like we're in agreement that that's the right approach. Just a couple of stray thoughts based on the presentations. The mayor mentioned concerns about permit amendments for as-built conditions, and Mayor, I understand your point. I just wanted to tell you not to overread that, because as facilities are built, there are often deviations from what they had planned to do in their application. Some of those amendments will be noticed to the public if they're significant enough. Some will not be noticed, but there is an opportunity for the public to have a voice and a process in those that we do deem significant. I do not have at my fingertips sort of the nitty-gritty of why one goes down one path and another goes down another path, but we could certainly get you that information if you're interested. So that's the first thing. And then Mr. Wright, you mentioned concerns. I'm sure you all have concerns about continuing violations. On that point, I would just encourage our Office of Compliance and Enforcement just to stay on this. And if there are continuing violations, we need to document and address those. That was all I had to say about item 9. I think we're ready to move on to item 12. Yeah. What are your thoughts?
There we go, sorry. My thoughts are to remand it. I won't go into much detail, but I would remand it and include language that says other factors as justice may require. And by doing that, reduce the penalty to $100. And I know the respondents already paid that, so that's what I would like to do on number 12.
I'm on board with that. This is a particular extraordinary hardship, and that seems appropriate.
Well said. Just to restate it a slightly different way for those following along at home, this agreed order indicates that there's an out-of-service station, and the respondent in this matter submitted information to the executive director regarding a financial inability to pay determination, and that was a very compelling argument to the extent that I was able to review the matter and the contents of that, and I believe it's appropriate to remand that as well. I have a motion that would capture both of those changes to our enforcement docket before us today.
I think we're ready for a motion.
I move that we adopt enforcement items 5 through 8 and 10, 11, 13, and 14, and that we remand item 9 to the executive director to include the plan submitted by Voestalpine dated November 11, 2019, and approved by the ED as an attachment to the order, that we include deadlines for any outstanding projects in the ordering provisions as technical requirements, and that we cross-reference Section 1, Paragraph 9.R regarding the permit amendment in Section 4, ordering provision numbers 3A and 3D. And finally, that we remand item 12 to the executive director to include an other factors as justice may require reduction to make the penalty amount to $100 as paid by the respondent.
Quick question on the point that you made about cross-referencing section. Is it 1 or I? And I don't know if it
Great question.
matters.
It looks like section I, paragraph 9R. So if I could correct my verbal motion where I said cross-reference section 1, paragraph 9R, I believe that's section I, paragraph 9R. Thank you, Commissioner Lilly.
Sure. I second that corrected motion.
I locked myself out of my computer this morning, so I'm improvising.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next items.
Items 15 and 16 will be taken up together. They are the consideration of the adoption of an agreed order with Luminant Generation Company LLC, Martin Lake Steam Electric Station, and corresponding revisions to the state implementation plan, and the consideration of the adoption of the Rusk Panola Attainment Demonstration SIP for the 2010 Sulfur Dioxide National Ambient Air Quality Standard. The Executive Director's staff is here to present these two items.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Donna Huff with the Air Quality Division, and with me today are Terry Salem and John Mentor of the Environmental Law Division. For your consideration for adoption today is item 15, the agreed order between the TCQ and Luminant Generation Company LLC, and item 16, the state implementation plan. Both support attainment and maintenance of the 2010 Sulfur Dioxide National Ambient Air Quality Standard in the Rusk Panola SO2 non-attainment area. Staff respectfully requests adoption of this agreed order and SIP revision. Thank you, and we're available to answer any questions.
Thank you, Ms. Huff. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka?
Not at this time.
Ms. Smith, is anyone signed in?
Yes, we have 3 people signed in wishing to address the commission, and 1 person who signed in available for questions from Luminant.
And I'll have you go ahead and call the names.
Our first name is Mr. Joshua Smith.
Good morning, Mr. Smith.
Good morning, Commissioner. My name is Joshua Smith. I'm on the phone. Thanks for allowing us to be here. I do appreciate it. I have 3 issues I'd like to touch on briefly. I know your time is valuable. First of all, the proposed state implementation plan and consent order is already, in fact, failing to protect against violations of air quality safeguards in the area around Martin Lake. Second, EPA has made clear that this plan is unapprovable under the Clean Air Act and its regulations. And third, TCQ can and should comply with the law by imposing technically available, cost-effective, and common sense pollution controls that comply with the Clean Air Act and satisfy the Texas legislature's mandate that TCQ protect public health and ensure compliance throughout the state. Addressing those one at a time. First, the proposed SIP and consent decree are already failing to ensure that SO2 violations do not occur. EPA designated the area around Martin Lake as being in non-attainment more than 5 years ago. Under the proposed consent decree, which was executed on January 18th and January 19th, Luminant was required as of January 22nd to comply with emission limitations contained in the document that are designed to ensure compliance with the National Ambient Air Quality Standard. And that's what TCQ intends for this document to do. But 5 days, or just a couple of weeks after that execution, on February 5th, the plant is already emitting sulfur dioxide at levels that exceed the National Ambient Air Quality Standard, are by definition unhealthy to breathe. This data is taken directly from TCQ's own monitoring webpage, and the readings show 1.5 times the sulfur dioxide max. So what we have here is a situation where the agreed upon order and SIP just fail, as a matter of fact, to protect against violations of public health standards. Second, aside from that recent spike in the state's own monitoring data showing violations, EPA has made clear that this plan is not approvable. And they've cited 2 reasons, fundamentally. The reliance on an unapproved modeling platform, and the reliance on emission limitations that are insufficiently protective of public health. Instead of adopting or revising the plan to address those concerns, TCQ forged ahead and approved the SIP and remarkably actually increased the plant-wide emission limitation for Martin Lake. We urge TCQ at this point rather than relying on these unapprovable modeling gimmicks and emission limitations that demonstrably do not work, to send this SIP back to TCQ for the evaluation and adoption of control technology that is demonstrated to work, common sense, industry standard pollution controls for facilities like this that will bring the area into compliance with the NAAQS.
That's time.
And if you have any additional questions, I'm happy to answer them.
Thank you, Mr. Smith. Appreciate your comments. I have no questions.
No, thank
Mr.
you.
Lindley?
No, thanks.
Okay. Ms. Smith, who's next?
Our next speaker is Ms. Lacey Tuttle Beckman.
And go ahead when you're ready,
Hello,
please.
my name is-
Yeah, go ahead. Sorry.
Okay, great. No, you're fine. Good morning, everyone, and thank you so much for your time. I want to advocate for more pollution control at Martin Lake as well. A little background, I've resided on family land that is surrounded by luminant property my entire life. This land has actually been in my family for over 150 years, and part of it was taken by eminent domain when the plant and lake was first constructed. Throughout my lifetime, I've seen and experienced firsthand many very concerning pollution and contamination issues with the plant. I remember during my childhood and teenage years, the lake would be so contaminated with mercury and selenium that many fish were found dead, and it was recommended that fish from the lake not be consumed because of the mercury and selenium content. Throughout all of these years full of extreme pollution, families have continued to swim, fish, and recreate in Martin Lake. As a child, I remember some days I could look out over our pasture and see the unprecedented volume of dark smoke and pollution pouring out of the stacks. Certain days were much worse than others, and I am still in awe of what I see coming from the stacks this day. Uncovered fly ash pits and landfill disposal pollution seep through the ground and contaminate our water supplies and ponds. And all of this pollution still continues today. Every industry and corporation must face rules, regulations, and quality controls. This industry should be no different than any other industry. When regulations are put in place, they should be implemented. Leadership should strive to not simply meet rules, regulations, and expectations regarding pollution control, but they should strive to exceed them. That has not been done by Luminant. Many local people and their families have been directly impacted by this toxic pollution from the Martin Lake plant. There are serious health complications throughout the local community that can directly be tied to the pollution and contaminants that Luminant has knowingly exposed this community to for decades. This is extremely concerning for me, especially now that I'm raising my own family on this same property surrounded by Luminant. Thank you so much for your time.
Thank you for your comments. We appreciate that. Colleagues, any questions or comments?
No, thank you.
Okay. Ms. Smith, who's next, please?
We have Ms. Paulette Gorey.
Good morning. And you might check your microphone and make sure it's turned on, your mute button. And we're still not hearing you, so Ms. Smith, how about if we come back?
That completes the list of people who have signed in and asked to address, but we also have Ms. Susanna Hildebrand from Luminant, who is online and available for questions.
Okay, Ms. Hildebrand, actually I see a hand and see her in the room and remaining seated, so I think there are no comments. And let's try our commenter, interested person who signed in one more time.
Again, Ms. Paulette Gorey.
Ms. Gorey, are you there?
Yes, my name is. Yes, I'm here. Can you hear me?
Loud and clear. There we go. Good morning.
Okay, I am so sorry. Good morning. I didn't realize my mute button was on.
No, that's quite all right. We're very glad you can join us. Go ahead when you're ready, please.
Yes, my name is Paulette Gorey, and I have lived in Beckville, Texas for my entire life. And I have been exposed to the pollution from Martin Lake for as long as it has been around. I remember when the plant first was built there. I live within close proximity, as well as most of my family, who have all been exposed and affected by the emissions from this plant. And we all suffer some sort of respiratory issues. And that's really, now that I'm retired, I can see that it's a real burden on my health care because my medications for my respiratory issues are a lot more than what I normally would pay. As most of my friends and family and neighbors who live here, we just want the plant to clean up so that those of us who reside here can all breathe easier and have much healthier lives, especially our next generation who plan to settle here in this area. And we just want clean air for them so that we could make Beckville and the surrounding area a better place to live.
Well,
Thank you.
Ms. Gorey, thank you. We appreciate your comments. And colleagues, any questions?
No questions, thank you.
Comments, thoughts? All right. Well, let's. I think we're finished with the interested persons. Thank them all for submitting their comments. Mr. McWhorter, what are your thoughts?
Actually, I believe Garrett Arthur is on the line.
Oh,
for this
forgive
one.
me. Yeah, Mr. Arthur, go ahead when you're ready. And you might double check your mute button. And we're still not getting you.
I do have a statement if he's unavailable.
I think you're
I
up,
guess I'll
Mr.
proceed.
McWhorter.
All right.
Thank you.
OPIC does not oppose adoption of the agreed order and SIP revision. We understand Texas must submit a SIP revision to EPA by March 9th of this year. And if EPA approves the submittal by September 9th, then EPA will not be required to promulgate a federal implementation plan and impose sanctions. OPIC also understands that federal regulations allow Texas to use an alternate air model to demonstrate compliance with the 2010 SO2 NAAQS, but EPA must approve use of the model. If EPA does not approve TCEQ's use of the alternate model, the SIP revision may not be acceptable. Finally, OPIC notes the agreed order would result in substantial SO2 reductions by eliminating the use of lignite, and new emission limits in the order are expected to reduce Martin Lake's allowable SO2 emissions by 70%. This agreed order and SIP revision are intended to achieve attainment and maintenance of the NAAQS for both Martin Lake and the Rusk-Panola area, but if EPA determines the area has failed to attain the SO2 NAAQS, the order provides that Luminant must recommend additional emission control strategies. Despite uncertainty and disagreement expressed in public comments, the Commission must act to address the Rusk-Panola area's non-attainment and the state's failure to submit required SIP elements. For these reasons, OPIC has no objection to adoption.
Thank you, Mr. McWhorter. Colleagues, I agree with that analysis. I think it's right. The agreed order before us provides an enforceable control strategy that helps support the SIP demonstration to bring the Rusk-Panola area into attainment with the 2010 SO2 NAAQS. I'm comfortable with the order and the SIP demonstration, and it's my view that we should move forward with adoption.
I'm in agreement.
Likewise.
I think we're ready for a motion then.
Since I have a motion, I will move that we adopt the agreed order with Luminant Generation Company LLC, Martin Lake Steam Electric Station, and the corresponding Rusk-Panola Attainment Demonstration State Implementation Plan for the 2010 SO2 National Ambient Air Quality Standard as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
The next item, item 17, is our public comment session. We currently don't have anyone signed in to speak.
Maybe we can unmute the line for a moment and see if there's anybody who wants to join us. All right, hearing none. Nobody's racing for the podium. Ms. Smith, please call the next items.
Items 18 through 21 are for closed session, and the commission will meet in closed session today in Building E, Room 2117, or 211S at, should we say 10:45?
Sure.
At 10:45, as permitted by the Open Meetings Act including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items number 18 through 21 as posted and noticed.
With that, the time is 10:40 a.m. and we stand in recess. Yeah. Yeah. Okay, that's perfect.
nothing, Ron. How are you doing? Oh, pretty good. Yeah, we can't figure out, we think there's a mic on, but they're all turned off. You know how that goes. I don't see any lights over here. Hello? Oh, I found it.
Colleagues, we're back on the record, having just met in executive session. The time is 11:05, and consistent with our discussion, I'm going to move that we direct the executive director to increase the salary of the general counsel by 7%.
A second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. And anything we need to do before we adjourn here, Ms. Smith?
I'll also note that the commission met in Building E, Room 2117 for closed session from 10:45 a.m. until 11 a.m. on items number 19 through 21 as posted in notice. Action was taken on 19 here in open session. No action was taken on 20 or 21.
Thank you, Ms. Smith. With that, the time is 11:05 and we are adjourned.